I'm Tina Nicholson. I represent Kimberly Allam in this action. Just to start off, this isn't a typical workers' compensation case in that there's a weighing of the evidence and you have the deferential standard where as long as the opinion is based on substantial evidence. This is a little different because there was...
Before you start, you're exactly right. It is a weighing of the evidence, and there's a lot of facts that some of which seem to conflict with each other. And I agree there's probably evidence to support a commission finding for the claimant. But is it not also substantial evidence to support the commission's finding for the employer in this case? When you take all of the facts, all of the testimony, read all of the documents, look at all of the medical evidence, is it not substantial evidence to support the commission's findings?
Not under the rulings of this court, Your Honor. And in this case, there was no defense presented. After the claimant presented her case, her prima facie case, the burden shifted to the defense, and they presented no defense. Now, under this court's rulings, an undisputed, uncontradicted testimony by the claimant must be accepted by the finder of fact as true, and it's binding and conclusive. And that's what the circuit court recognized in reversing that. And I'm sure the court has read my briefs, and I can cite the cases if you wish, but that's been in several cases. If you have undisputed, uncontradicted testimony by other evidence, on the finder of fact, that's binding. It has to be taken as true. Unless...
Yes, sir. When she stated that she reported it to her supervisor, and he told her that it was probably due to an other type of activity that caused the injury, and instructed her to eat a banana because her potassium was low. She also indicated that she walked around, I believe, for several days holding her rear end. Now, did the supervisor contradict that testimony?
No, Your Honor, there was no evidence presented by the defense at the hearing. In fact, the manager to whom she reported that injury, Roger Wilbanks, was at the hearing, and after she testified that, he left the hearing and did not return. There was no contradiction by Waffle House as to her statement. And that's where I'm going with this. It was totally uncontradicted. There was no evidence suggesting, there was no one that said, no, she didn't tell me, no, she didn't fall down. And under this court's rulings, that must be taken as true unless it's inherently improbable or unreasonable. So when you look at the ALJ's order, it's not like, well, we're weighing this witness's testimony against that witness's testimony. There's only one set of evidence, and that's the claimant's. And it has to be taken as true unless it's inherently improbable or unreasonable. So we have to look at the ALJ's opinion in that context, not so much is there a substantial evidence, but was her testimony inherently improbable? And if you look at those three items that she laid out as a basis for her opinion, that doesn't rise to that level. For instance, she didn't file a claim. And as the court pointed out earlier, I don't even really know what the judge meant by that. She did file a claim. All she's required under the statute is to give notice to her employer. She's not required to fill out a form or submit something to the commission to give notice, which she gave oral notice, and that satisfied her obligation under the Act. And then 5 months later, and as the court pointed out, she has 2 years. 5 months later, she filed her petition to controvert. So I really don't know what the judge means by that. The fact that she waited 5 months when she had 2 years does not make her testimony inherently improbable or unreasonable.
How does it contradict her claim that, as we're talking about the delay in filing, I guess, that the administrative law judge is referring to, and also the decision to submit it on a private insurance? How does that play into the decision to deny benefits?
Well, Your Honor, I mean, I have to admit I'm a little bit confused about her reasoning on that as well. The reason being, all of my clients, if their claims are controverted, they use their private insurance. I mean, because what is the alternative for that person? To go without medical treatment until the case goes up through the Court of Appeals, which this case has taken 4 years. So if she had not used her private insurance, and we're talking about a waitress at Waffle House, not a person with private means who can afford surgeries and whatnot on her own nickel, her only other option would be still today probably in a bed awaiting medical treatment if she didn't use her private insurance.
The doctor had refused to treat her if she had not used her insurance? Private
That
insurance?
I don't know, Your Honor. I just don't know. I'm not familiar with the structure of all that kind of stuff. But she wasn't on Medicaid. She was a working person. So I'm just assuming, she had the insurance right there. She was paying for it, so she used it.
Ms. Nicholson, the questions that I asked Mr. Jones a moment ago, I think I boiled it down to the fact that of the 3 reasons, I think there's one that requires review, and that is the question of the medical records. That clearly, and I think Mr. Jones admitted, or didn't admit, but would concede, is that if all the medical records said that she'd reported this to be a work-related injury, then we would not be here today, and this matter would have gone through the normal process. But the fact is that there are some medical records, I guess 4 out of the 5 doctors' records, that does not say this is a work-related injury. And the claim is, or at least the ALJ, I believe, said that this has caused some doubt, some reason not to believe her later testimony that she told them it was work-related, or her claim that it is work-related.
And I think that's a really good point to address. Miss Allam, as it states in the record, has a 7th grade education. She's just a crusty, hardworking lady. And I think if you look, especially her testimony, she said some of her doctors asked how she got hurt, some didn't. She said she told some, and she said as far as Dr. Summers, when she went to Dr. Summers' office, that's the form that the court referenced earlier where she checked on the job injury and other. And her testimony at the hearing when Mr. Jones questioned her about that was, well, I was filling out the form, I put other, and then I saw on the job injury, so I checked that. But it was written in pen, so I couldn't uncheck other. So, and that was 2 weeks after the injury. We're not talking about seeing providers over a period of months, and she went off to all these. She saw Dr. Metter. Dr. Metter's record is just, he wrote she had an injury, a fall earlier. He didn't write down she fell at work. He also wrote down that she had been to UMC, I believe, and she testified she never went to UMC. So there's really some confusion about what he was actually writing on there. And we don't have any medical records from UMC. I requested them and didn't get them. So I don't know what Dr. Metter was writing. Dr. Summers mentioned an injury. I don't know what she told him. I don't know what he wrote. As the court pointed out, once they know that you're filing on private insurance, if they write lifting injury or, on-the-job injury, the private insurance is not going to pay. And I think doctors are generally smart enough to know that. Dr. Russell Carlisle did write in his records that she was injured at work, and that was the chiropractor physical therapy doctor that she went to see after her surgery. So, and I will tell you, when workers' comp clients come to me, the first thing I tell them is be sure and tell your doctors that you were injured at work, that they write it down. Ms. Allam came to me 5 months after she was injured, so she didn't really have that counsel. And if you take it in the context, again, you really have to take it in the context of a 7th grade lady with no education. She works 80 hours a week. She's in pain. Her own testimony in the medical records, she's in pain. She's working 80 hours a week through the pain. As I pointed out in my brief, she was getting epidural injections while she was working 80 hours a week in pain. So, she's focusing on her treatment, perhaps, and at that point she wasn't even thinking about building her workers' compensation case for evidence. And those are the kind of circumstances that this court has said previously, you don't have to build your case in your medical records. The absence of the notations by doctors, it's great. The ones that say, yeah, Miss Jones came and she fell down at work and now she's hurt, those are great ones. They never come up on appeal, because that's just fabulous. But in this case, and in other cases, such as Bryan versus White and Leatherwood versus Frito-Lay, those are cases where the court said, yeah, the fact that there's an absence of corroboration, sometimes a total absence of corroboration of the claimant's testimony in the medical records, doesn't prove anything. And the ALJ, and I think was straining a point there, as so is Waffle House. The fact that it's not there doesn't make it inconsistent. The fact that it's not there doesn't make it contradictory. And the fact that it's not there doesn't make her testimony inherently improbable or unreasonable. I mean, that's just a giant leap. And there is some corroboration. She testified, and it's in the medical record, that she wrote in Dr. Summers' questionnaire that it was an on-the-job injury. She also reported it to Dr. Russell Carlisle, who noted it. So, what is that, 2 out of 4 medical providers noted it. So there's corroboration. There's no contradiction. So, and there's also there's a lot of strain by Waffle House about her saying it was a lifting injury at one point and a fall injury the other. And some of the stuff is just, again, they're straining at the facts to try to build an inconsistency. What the petition to controvert said, and I know because I wrote it, Ms. Allam did not write it, is that she was injured while unloading a truck. That's what it said, unloading a truck. And her own testimony at the hearing was, I was unloading a truck when I slipped and fell on a pack of ketchup. She was carrying a box, as the court referenced earlier. She was carrying a box, unloading a truck, and she slipped and fell on a pack of ketchup. Now, some doctors said it was a lifting injury. Some doctors said it was a fall. And Ms. Allam testified, well, I don't know what you say. I was lifting a box and then I fell. And again, at the time that she was reporting to this to her medical provider, she wasn't trying to build her case. She was just trying to get treatment. And she did testify that some of them didn't even ask her how it happened. So all of this doesn't make her testimony inherently improbable or unreasonable, which is the standard we're looking at. There's not, in this case, there's not really a weighing of the evidence because there's nothing on one side. It's just this evidence on her side that she's presented. And did she make a prima facie case? Well, if you take all of her testimony as true, she did. I mean, the standard is not high for the claimant because we want, the purpose of the act is to help the injured claimants. And so the standard for a prima facie case is not high. And she's met it. If her testimony is taken as true, she fell at Waffle House unloading a truck. She reported it to 3 managers within 24 hours, who, as I mentioned, one of them was right there and never did get up and deny it. And the other thing is she got medical treatment that was consistent with the injury that she reported. The causal connection is supported by the medical records. And as I pointed out in my brief, she went to a doctor regularly, Dr. Mehta regularly, prior to her injury, never reported back trouble. From the date of her injury, she had nothing but back trouble. And if you look at this court's decision in Leatherwood, that's exactly what they found there, is that just from that injury onward, there was a worsening of the condition, and this court found that to be consistent and sufficient to establish the causal connection between the injury and the accident. Are there any more questions from the court on these issues?
Thank you, ma'am.
Thank you.